And now to the murder trial of late Senzo Meyiwa, who was killed in Vosloros at his girlfriend's house in Kelly, Kumalo, resumes at Pretoria High Court this morning after a 2-week break. It is a trial that has left South Africans glued to their screen. In the month since it began, the witnesses have given evidence with Meyiwa's best friend, Mpumelelo Madlala, who was in the house at the time of the murder, implicating accused number 2, Bongani Ntanzi, as one of the alleged intruders. Meanwhile, the recent testimony by Constable Sizwe Zungu appears to have introduced significant new information to the trial. Zungu has described how some of the accused disappeared from a gathering at the hostel and hurriedly returned carrying firearms, and how one of the accused changed an item of clothing upon return. Zungu also claims the accused celebrated with a bottle of whiskey, and 5 men are on trial for the murder of the soccer star who was shot and killed in 2014 while at Kelly Kumalo's home in Vosloros, east of Johannesburg. Now to talk about these, I'm being joined live by a legal expert, Mpumelelo Zikalala. Good to have you join us.
Good morning to you, and also good morning to your viewers.
Yes, good morning. Good to have you join us. Now, defense to the tests, the state witness Constable Zungu, on the evidence he brought to court, which many have, questioned on why it took him so long to give a statement. What are the key highlights for you on his evidence?
Especially is that one of why did you keep quiet so long? Remember, you're not just an ordinary person, you're a member of the SAPS, African Police Service. So you know better which channels to talk to and which individuals to discuss these matters with. Secondly, you are dealing with a matter that has been in the public eye for far too long. So you would know the importance of being able to finalize this investigation as soon as possible. What is most important for the court is that the quality and the quantity of the evidence is important in order for you to come back with the conviction. So if you're going to provide evidence which is not credible, then you may find yourself having trouble. Secondly is the manner in which you behaved on the day. Now, as a member of the police service, why take off your gun and leave it in the hands of somebody else? Why you do that when you are attending a party, especially when individuals that are attending the party are not known to you? Aren't you at least concerned that your gun is going to be stolen or anything untoward is going to take place? Secondly, on the celebrations part, on what insinuation did you think that they were celebrating? You were attending a party, by the way, on that day. So the consumption of alcohol is something which is going to happen on a regular basis. So those are the questions which are going to come in. But the most important one for me is, why keep quiet for this long? Secondly, why didn't the state provide his information much earlier? Because if that was done, this particular judgment that has taken place for 3 weeks would not have occurred at proper pretrial conference, and the disclosure of information and also the evidence that Mr. Zungu was going to testify had been stated much earlier.
Now, let's look at things on the flip side. What could be the potential impact of his testimony? I mean, what could be the legal implication if his testimony is tested and then found out that he lied?
Now, lying under oath is actually perjury. It's a common law crime in South Africa in which if you are found guilty of it, you can be sent to prison. The reason is, don't waste the court's time by providing information which is false. But most importantly for other individuals to say, what's the motive for lying? Are you trying to protect someone? Why do you want to implicate these particular individuals which are in the witness box? So if you go on the witness box and you lie, that's when you're going to find yourself into trouble. And that's where the whole context of asking the question, why did you wait so long before you provided this information, is going to become very crucial, especially for someone who's a member of the police who ought to know how crucial it is for information to be provided as soon as possible. But most importantly, knowing the proper channels in which you talk to, even if you fear for your life, if you want to disclose the evidence that you have in your possession.
Let's take a look at the comportment of the judge. What's your assessment on how the judge keeps interjecting the defense and sometimes even giving evidence? What does the law say about this, in your own opinion?
Now, the presiding officer is almost a supervisor for the court, in ensuring that the court is able to flow in a much more efficient manner. So there are going to be questions in which the judge is going to say, I need clarity in this particular question. I want to see how you're going to answer for it. I'm not arguing for the state, I'm not arguing for the defense. The only stance which I'm taking is that I need clarity as to how things are supposed to be done. I think the judge is quite adamant in saying that I want the matter to be done and dusted within a reasonable amount of time. There must be no time wasted which is going to take place. And in certain instances, you might find the judge overstepping the mark a bit in terms of he's being overzealous in getting the questions to be answered. But that is not a transgression which is enough to cancel this whole process or to come and conclude that justice has not been served. The manner in which the judge is behaving, the manner in which most judges, when it comes to as presiding officers, would behave in any matter, especially the matter of this magnitude, a matter that has international and local media looking at it, focusing on how the judges are supposed to do its job. But then there is a safeguard from the side of the defense and even the NPA in terms of saying, if you feel that the judge is not doing things correctly, you have an obligation to stand up and say to the court, we're being prejudiced by the manner in which you're conducting these investigations. We want to put these proceedings, we want to put it on record. So should we lose this matter, we're going to appeal. It must appear on the record that we raised our concern and you ignored us, which is the reason, by the way, in which the judge resolved that I'm going to give you a 3 weeks period in order for you to go and peruse these particular documents, because I don't want you to come back if you end up losing this matter and say that you did not get enough opportunity to prepare with the information which is provided to you, or the information or the evidence that was being dealt with by the court.
Okay. Now, Mr. Zikalala, so far there's been more than 100 witnesses from the state that has come forward. How much longer are we to wait for justice to be served in this case?
I don't think the state is going to call all those witnesses. I think any other witness that would come now, simply repeating what the other witnesses have stated. We've covered the crime scene, we've covered the forensic investigation that has taken place. We've even covered circumstantial evidence which is provided by Mr. Zungu as we speak. So other than that, there's nothing more or nothing new or nothing fresh that you can be able to add in these proceedings. So I do think, or maybe predict, that maybe by the end of this week, if not the end of this month of this session, the state is going to end its case and say, this is the evidence that which we are providing. We are now handing over to the defense. And from the side of the defense, I think the first line would be to say, let's apply for something which is called 174 application in terms of the Criminal Procedure Act. We are going to state that on the evidence that has been provided here, nothing is solidified to such an extent that it warrants our clients to go into the witness box and answer. Can you please adjudicate on that? Because there's nothing in which we need to answer to. Fingerprints have not been tested in a positive manner for all 5 accused. Even the guns have not been tested in a much more positive manner. You have person who's saying this is hearsay evidence. They went out and then they came back, however, was not at the actual crime scene, and all the other stuff which are actually showing the weakness of the state's case. So I think from the defense, they may say, we want to apply for 174, and if that application is successful, that means it's the end of this case. These individuals will be acquitted.
All right, thank you so much for your insight. Mpumelelo Zikalala, thank you for your time this morning.
Thank you very much for hosting.